Welcome to the Expert Network Team Podcast. Sweeping new laws affect every business owner of nearly every size business in the USA. They are stressful. The fines for non-compliance or ignorance can be excessively expensive if ignored or incorrectly filed. As we're about to find out, it's good to have an expert on your side. I'm Karl Frank with A&I Wealth Management, one of two hosts, along with Nathan Merrill of Goodspeed and Merrill for today's podcast. As a quick reminder, the Expert Network team provides free consultations. We'd love the opportunity to be of service to you or someone you care about. Just scroll the liner notes to contact one of our experts or today's guest. And please, share this podcast with anyone you think might find it interesting.
I am your eager host for today, Nathan Merrill from Goodspeed Merrill, and with me I have Karl Frank of A&I Wealth Management.
Hey Nate, how are you, buddy?
I'm doing really good, and it's good to be back. We've missed you. You've been out for a couple of weeks,
So yeah.
I've learned over that period of time that you're the glue that keeps everything running here.
Okay, yes, yeah.
So we need to figure out who, not how for you on that one. So we make sure that we keep momentum going. And our distinguished guest today is actually someone from my firm. Very proud to introduce Charlston DeGrood from our corporate team. And we've got some really interesting stuff. Welcome. Oh, Chase. You go by Chase, sorry.
No problem.
Charlston DeGrood Chase. So if you hear us refer to a Chase in the room, that's who we're talking about. But welcome.
I appreciate it. Thank you for having me. Although I might have to push back on the distinguished part of the introduction.
No, we'll make you distinguished by the end of this, and everybody will concur, I'm sure. We've got some really interesting and compelling subject matter to talk about today, at least from a legal perspective. I think from a broad perspective, for anybody who's been following some of the more far-reaching legislation, I'll have you tell me when this was passed, but I think it was in the last year, what is called the Corporate Transparency Act.
Yeah, from my point of view, it just feels like a nuisance to business owners. Right? I don't understand what's going on. It seems really complex. It seems like it's just another threat that I'm facing. I have no idea what I'm supposed to do and whether it affects me or not. Why do I have to deal with this?
Right. The why is, I think, understanding the why helps to explain why they're doing what they're doing, what their response is. I don't know that it necessarily makes sense.
Okay.
So
well, there you go.
I do want to qualify that everything we're going to say was a justification and what they're requiring. It reminds me of some things that happen in the tax world where they do an informational, this, that, or the other that you file, and you're like,
right.
Where does this go? It just goes into some
nowhere bill.
Who knows what they're doing with it? Maybe yeah. So without further ado, Chase, I want to ask you kind of the kickoff question that Karl was asking. What is the Corporate Transparency Act? When did it come into play? When was it effective? Just kind of gives the legislative history, brief-wise, not in depth, but.
So it was started, from my understanding, it started to get passed around a few years ago, 2019, I think. And the final version of it was put into place more or less 2022, late 2022, early 2023. I forget the exact dates on this one. Then once it was finally passed, they gave us a little bit of a grace period per se until it goes into effect, going into effect the first of this year. And
so that grace period was pretty much most of last year, as I recall. And something our listeners should understand is, when did they finally get the system set up so that people knew how they were going to comply with this?
Literally January 1st, 2024.
So just had to throw that little tidbit in there because we were having CLEs on this, just so everyone understands. We were having CLEs on this, middle of the year, late September. And at that time, still nobody knew. They knew what we had to do to comply.
So that's
in theory.
In theory.
Education, a CLE.
Yeah.
Yeah.
But we had no idea how we were going to advise clients to actually do it because the system wasn't set up to receive the compliance. It reminds me a lot, if you recall, in the Wayback Machine when the 2017 Act passed, and the 199 Cap A came into being, and Mike Miller, our CPA, host, was like, we have no idea.
We don't know what we're doing.
We don't have the forms. We have
Right.
no idea how we're going to comply with all this. But so it's a lot like that.
Yeah.
So,
well, good luck.
Thanks. Yeah, I feel like everybody's kind of scrambling to understand this thing because just the way things are usually done, Congress issues a statute, then they pass it off to the administrative agency that gives guidance and tells us, oh, this is how we're going to interpret the statute. And then there's further guidance. Oh, we're going to issue tax-wise, like private letter rulings, SEC no action letters, stuff like that. That gives us more context into how, okay, this is how we're really going to interpret specific search situations. There hasn't been any of that here. So everyone's really just scrambling to say what's really happening.
well, sorry, Karl.
What was the what?
Why? What are they trying to accomplish? I'm with you. Like,
What?
why does this statute, this rule, this whatever need to exist in their minds?
So the general goal is to really impose some reporting requirements for all these quote unquote shell entities. There's a lot of entities out there that are formed for one purpose or another. They don't really operate an active business. They operate as holding companies. They
Liability
operate
protection,
flow through entities.
holding
And-
companies. Yeah,
Mhm.
I mean, we do this all the time, which is why it's kind of silly. Not every quote unquote shell company is some sort of nefarious activity, but their argument is if it doesn't operate an active trade or business, what? We want
to know who owns the company and who has control over the company is what it goes down to
prevent what
to
kind
prevent money
Financial
laundering and
crimes?
financial crimes.
Okay.
So all these just a little bit more context, the Corporate Transparency Act is going to be enforced by FinCEN, which goes for financial crimes.
Okay,
FinCEN is run by the federal government,
Treasury, yeah.
by the U.S. Treasury. Okay, interesting. Not the Justice Department. It's not like a.
It's not like FBI, but they have FinCEN, for example, I think was implicated, not to get political, but recently with some of the hearings that occurred around January 6th, there was a bunch of collaboration with large US banks to extract data on individuals and
Figure out who was there.
not only to figure out who was there, but they gathered in. The hearing just happened last Thursday, so March 7th, and the report is just, I don't want to suggest it's alarming, but it's alarming how much access they had to American beyond like reasonable search and seizure. Like
A lot.
there was no probable cause. They were just searching databases full and focusing on particular words. I won't say which words or which types of activity, but you can assume guns are in there, right? Anybody who purchased a gun or went to Dick's Sporting Goods or Cabela's, they pulled that information. And this is the division of the US government that basically monitors all of,
They're looking for money launderers.
well, in that case, they were looking for a profile of a type of American citizen.
Yeah, that's really interesting.
Yeah.
Okay.
But this gets back to just almost a presumption that shell companies are used nefariously. Therefore, we're going to look at every shell company and its ownership structure. What they do with that information is ultimately.
Yeah, what are they going to do? What do we have to report now when we form?
Yeah, let's talk about the reporting.
Yeah. So the what info needs to be reported. So we should rewind a little bit and go into exactly what a reporting company is.
Okay.
Yeah.
Rather than before we go into what they need to report. So a reporting company it's incredibly broad. It's meant to cover pretty much everything. They're limited liability companies, corporations, or quote, any other entity created by filing a document with a Secretary of State or similar office under the law of a state or any Indian tribe.
Which isn't otherwise exempt. And then they basically define what exempt is. And exempt is going to be
23 different exemptions.
Yeah. And most of them are kind of obvious, like banks are already
banks and
publicly traded companies,
501c3 nonprofits.
Yeah.
And also an interesting exemption, which really reinforces the point of how this is targeted at these quote unquote shell entities, is one of the exemptions around one moment, I just had it up, but I forget the exact cutoffs, but it's with over 20 employees, $5 million in gross revenue.
Yep.
So
that's your operating
companies.
business. That's what they presume a non-nefarious or non-suspect operating business. But one thing I want you to talk about on this one, because this gets into a lot of work I do, and I imagine a lot of businesses are structured this way. If that operating business is owned by a holding company, which is owned by individuals and trusts, how do they look at that then? Because I believe the way the exemption is worded is it's direct ownership in the operating company. But if there's a holdco that is not otherwise exempt because it doesn't run an operating business, that whole operating business exemption is just gone.
That from my understanding, that reporting entity would then essentially, yes, they would need to report that holding company would be a reporting company, would be required to file a beneficial ownership reports
For both entities, even though the bottom entity is technically exempt, but because it's owned by a reporting entity, both entities have to report or be exempt, but because the ownership of the operating company, and maybe we're getting into one of those gray areas where it's like fact specific, but as I understand it, if your operating company exemption isn't directly to the beneficial owners, if it's owned through a reporting entity, then it becomes a reporting entity itself, even though it's otherwise would be exempt. But
well, let's look at exactly what what FinCEN says. So 20 full-time employees, entity has an operating presence at a physical office is another thing, $5 million in gross revenue. They're not, I guess it is going to be one of those gray areas then. They're not going to explicitly say quite yet.
yeah. So most people, I think, can operate under the assumption if they directly own their business and it meets those criteria, this isn't legal advice, but they're probably going to be okay and don't have to file a FinCEN. They're not a reporting company. So then we don't even look at the issue of beneficial ownership and control and all that sort of stuff. But let's assume that they aren't at 20 million of revenue yet. So it doesn't matter how many, or 5 million, it doesn't matter how many employees they have. They're now in the reporting category. And that could be a fair number of the people who listen to this podcast.
Oh, yeah. So the smaller companies or the smaller revenue ones are the ones that are targeted.
Yep. Small business.
Lucky us.
How is that fair? You said life was fair, Karl. But then what happens if let's say you've got entities set up for real estate holdings, not going to have 20 employees there, asset protection, liability protection, a lot of the stuff we do for clients, a lot of stuff we've talked about, Karl, is setting up entities to own individual real estate holdings, that sort of thing.
Sure.
Those are all going to be reporting entities. What does that mean?
So what they need to report, you mean?
Well, what's the next? Yeah, because you said we have to rewind to first talk about what a reporting entity is. Now that we've kind of established, we have a cursory understanding of what a reporting entity is, which is pretty much everybody but the 23 exemptions.
Yes.
The most relevant one to most of our clients would be 20 employees and 5 million in revenue. So we're assuming now that they don't even hit that. What's the next step?
The next step is to figure out who the beneficial owners are. What constitutes a beneficial owner in this case. And they give us two different definitions. So a beneficial owner is either one, someone who owns or controls at least 25% of a reporting company, or has quote unquote substantial control over the company. And that's a whole nother, the substantial control part is a whole nother bag of worms, which we probably
Tell me about that bag of worms.
Later.
We like fishing.
Okay. So substantial control, they give us FinCEN gives us a pretty, I don't want to say exhaustive, it may be exhaustive in their mind, but it really doesn't provide a huge amount. So senior officers, presidents, CFOs, general counsel, CEO, or any officer who performs similar functions, which is supposed to be a catch-all. Yeah. And anybody who has appointment or removal authority of any senior officer or a majority of the board of directors. So anybody who can appoint or remove the president, or anybody, let's say, this kind of goes into the ownership portion of of being a beneficial owner, but someone who owns 60% of the votes for the board of directors and can unilaterally appoint or remove most of them. Anybody who's an important decision maker, defined as one who directs, determines, or has substantial influence over important decisions made by the reporting company, including decisions about the reporting company's business, finances, or structure. And then there's a catch-all, which they have to include multiple tiers of catch-alls, of course. And just any other form of substantial control is how they define their catch-all. So one example of where this can get interesting is just how nitpicky they're going to be with this, especially if we interpret it strictly. Y'all are familiar with fractional executives, right?
Oh, yeah, sure.
Like a fractional CFO or someone that you employ part-time.
Basically just hire them as, I
Yeah.
would think 1099 would be my guess.
Yep. Yeah, you bring them on, generally bring it on, 1099 basis, usually for reasonably short appointments, from what I understand. That,
Build your financial stuff.
yeah.
Hey, Jeff.
Hey, guys, are
We have a late arrival to our panel here. Jeff Krommendyk.
Chase, pleasure to meet you.
You. How are you guys?
Good,
Sorry.
man.
Good.
Thanks for joining us.
So
Fractionals.
fractionals. So technically, they're still an executive. They exercise a substantial control. So let's say you bring on a fractional CFO that's you're struggling with their taxes, bring them on for a few months.
Or whatever.
That triggers the reporting requirements, and the reporting has to be done quickly. So once again, it's just another burden on businesses.
Okay, so you just raised another issue that I want to hit in this first half of this discussion. So we've talked about CTA, what they're trying to accomplish, who a reporting company is, what that company now has to report. Is it just the beneficial owner information, or is there company information that has to get reported too?
Beneficial ownership information as well as company information.
Okay. Now timing. So let's talk about the current timing, but also the kind of the statutory timing, because they've given some, as I understand it, extended grace periods in this first, recognizing that there's going to be a lot of activity. A little stat here while he's preparing to answer this question. It's estimated 33 million businesses are likely subject to this reporting requirement in the first year. So talk about the reporting.
The timeline?
Well, the timeline, like everybody's got to report basically in 2023, and then talk about the other reporting triggers.
Yep. So just to lay everything out, there's the 2024 reporting, basically any company that was already.
Did I say 23?
Yeah.
Sorry, okay.
No problem. There was any company that was organized before January, that was already in place before January 1st, 2024. They have to have their initial beneficial ownership reporting done by the end of 2024, December 31st. Then, but in the middle of during 2024, if any other entities are created during 2024, the beneficial ownership report needs to be filed within 30 days of the entity's formation.
Which they
with the
extended,
Secretary of State.
they extended that to 90 days this first year, did they not?
That's
my understanding.
They'll have to circle back to that.
Okay.
One.
Yeah, I think because we're in the process now of filing some that we formed early in the year, but the statutory requirement was 30 days, but there's an extended grace period, at least for right now, to 90 days. But then there's the, like you say, pre-existing entities all have till the end of the year.
Yep. And then once it's, let's say we fast forward a year, January 1st, 2025, everything's in full swing. We're no longer in the grace period. It's 30 days. There's continuing reporting requirements for entities. So entities have to file an updated beneficial ownership information report when there's any change to any of the quote unquote required information, which we'll go into in a second, about the company or its beneficial owners. And that has to be done within 30 days of any change.
So, and we're going to blow your mind on this one, but, and then the ongoing new entities, that's where it then resets, to my understanding, to the 30 days. So new entities, 30 days, changes in any of the reporting information, 30 days. What if you don't?
If we don't, if you just don't file?
Yeah.
Willful noncompliance. Oh boy. Okay, let's do some reading. So this is mostly strict liability.
Which means
not
an intent crime.
Yeah, it's not well, let me rewind a little bit. I said willfully, there are they're pretty liberal with the term willful. So this is really a strict liability.
Meaning if you
statute,
don't do
meaning-
it, you were willful.
Yes, if you don't do it, you are subject to the penalties.
The I didn't know this law existed is not a defense.
Yep. And
Ouch.
so failing to complete a BOI report, $500 civil penalty for each day the violation continues, up to $10,000, and up to 2 years imprisonment, or both.
Did I tell you I'd blow your mind?
Yeah, that does blow my mind.
Does it really blow our minds though?
I don't know. Maybe not.
Okay.
We can talk about that in the next podcast, because that's where we get into the esoteric stuff.
Yeah. How do you file?
How do you file? The FinCEN has a website. They do have a portal.
It's another
And-
website.
Yes. And
Well, and before you get into that, I think there's a qualifier here that people need to be aware of. And at our firm, we are definitely trying to address this, which is some of the information. We didn't get into all the information. I think we should go over that before we talk about how we file, because what we're filing, I think, is critical to understand in terms of why we shouldn't just approach this casually. But effectively, you will be transmitting, what do they call it? Personal identifying information, PII,
Right?
all that stuff that we've been told we need to protect with, our
Yeah.
lives
Of course.
from disclosure. If we collect it from clients that, we have to have. So those who are helping, firms like our own, who are helping to assist in compliance, are now being forced to gather PII as part of the compliance with this law, which is causing a lot in the industry. CPAs, attorneys, anybody who's helping with compliance has very serious concerns about this, because not only is, and I want you to address this as well, the liability of the person who pushes the button to submit the report is making certain perjuries, type statements that it's all true and correct, and they will take personal liability, as well as just the gathering, handling, and transmittal of this PII. I had one consultant that we're working with to develop a solution that suggested this is one of the most reckless laws he's ever seen. Granted, we've seen a few, but this is so reckless in terms of handling of
Wow.
PII and compelling private enterprises to collect and transmit PII over internet channels. Risk manager, I can see your mind starting to swirl. And we've had conversations with you on
Down
this.
this road with you guys.
So maybe we can talk about some of that in the second half of this discussion, but talk about the information that is.
so the information they're requiring is the reporting company's full legal name. This is reporting company, let me just emphasize that. The full legal name, any and all trade names or DBAs, complete current US address, and a tax identification number or employer identification number, which is pretty standard just for the entity.
Although,
It's the,
let's say 10 years ago, you filed a DBA that you stopped using and you forgot about it completely, strict compliance.
that's a good point.
So now you have to make sure you're going back and checking all of your I mean, there's just a ton of like CYA stuff that's going to be going on here to make sure that compliance actually happens, because, well, go on, the list gets better.
So this is the beneficial owners and applicants, company applicants, which is something we also should discuss a little bit. So the beneficial owner's full legal name, date of birth, complete your current address. It has to be a residential address, and except for company applicants, but that goes into the company applicant issue again. Then the real kicker is the unique identifying number, issuing jurisdiction, and an image of either a US passport, state driver's license, or any ID document issued by a state, local government, or tribe. So they have your passport.
Or your driver's license and your picture.
Is this just for LLCs?
No, sorry, you missed that part. It's
Yes, sure.
basically any entity that is formed through a filing throughout the United States. There's some exemptions from it, like insurance companies are exempt.
Yeah.
So banks are exempt,
I think
brokerage
broker-dealers.
houses, what
I
else?
think broker dealers.
Broker dealers, yeah. Financial institutions generally are exempt. They're probably mostly thoroughly regulated by FinCEN, that they don't feel the need to. And then charities, you said 501c3s. There's a list of 23 types of exemptions. In that exemption, just to recap, again, to emphasize for our listeners, 5 million in gross revenue, and 20 employees. pretty sure it's gross revenue.
Yeah.
So if you're an operating business, but that doesn't get into holding company structures like we often see set up where you have holding company operating multiple entity level divisions underneath. That may actually have a separate payroll company to manage all of their entities, in which case they don't have payroll. So there's all sorts of broad net happening here, likely as a result of the drafters of the rules or regulations not understanding how business structuring actually occurs, which is not uncommon.
So maybe you guys touched on this, but what do you think their motive behind this is?
Ostensibly to prevent money laundering and financial crimes. Because in a lot of people's minds, oh, these shell entities equal bad, equal criminals.
And in some cases that's true, but you set up an LLC to hold a piece of real estate that you're purchasing to protect yourself from the liability of that entity from you and you from the entity. That gets swept into this. There is actually one court. Are you up to speed on the court case?
Yep, I have it pulled up
Alabama,
right over here.
Yeah.
National Small Business United v. Yellen.
So let's close out this podcast, talk a little bit about this, because I do want to get to how you comply and some of the more esoteric, like risk management concerns that arise in that. But talk about where this case leaves us at this point.
So it's a reasonably long opinion. They challenge the statute on a number of constitutional grounds. The ability to exercise foreign powers. The justification behind that was, oh, we need to bring us into compliance with the foreign regulatory regime around this. The court threw that out and said Congress isn't really they don't have the authority to do that in this situation. The second is the Commerce Clause. But the CTA entrenches these reporting requirements in the filing of the business itself, which is not engaging in interstate commerce. Yeah. It's with the internal Secretary of State. So they throw out the Commerce Clause argument. And then the third is the tax and spend, which was the court didn't go too much into detail on that, but they did not find it convincing.
Okay. So did they stay the enforcement of this provision nationwide? Where does this leave us procedurally?
Procedurally, it's on, the appeal was, I think it was either just filed or just accepted a couple days ago. So the Supreme Court will most likely be hearing it. But so
that could not be until June or something like that.
It could be for a long time. There's no stay on the enforcement right now that I'm aware of.
Okay, but that was my understanding as well. We're still expected to comply with this, even though one court has found it to be beyond the constitutional powers to even enact.
But one caveat with the opinion that was interesting, and I personally don't think this ruling I don't think this decision has a lot of teeth to it, because the court explicitly states, I have it pulled up on here, just says these cases, they cite a bunch of cases in there, and these cases also illustrate how easily Congress could have written the CTA to pass constitutional muster. Essentially, they're saying that, oh, we do a couple edits to this law and then it's good to go, essentially. So even if it goes all the way up the chain, it gets struck down.
You have Justice Roberts, who's more than happy to reinterpret words to make it work.
Yeah.
Like he did with Obamacare. So before we close out, just maybe some closing observations for you, Jeff, Karl, you guys are hearing a lot of this for the first time.
Yeah, I've been getting the letters and the emails, both from my lawyer, you guys, and my CPA, and I don't understand it. And now I understand that I think you guys are asking us to do it, but I have to put a photo of my driver's license in there. And we have a number of small entities, mostly for legal protection, like you're talking about the real estates in different entities to protect from lawsuits that could screw up all of families' money.
Right. And I'll speak to the kind of how the filing environment is coming around.
Yeah.
To be clear, and this is great that we get to have this conversation in front of the world.
Yes.
No, we're not necessarily asking you to do it yourself, but we're basically giving people the option. This is such a significant and personal kind of thing. Like, do you want to take care of your own CTA compliance, or do you want to, you know, it's a service above and beyond what most people
Right.
got like into when they set up their companies. And that's why we want to make sure that people are aware that this means we have to impose stricter management of that information and that sort of thing. So
Because you have to protect yourselves.
yes.
Yeah, for sure.
Yes.
Well, this was news to me up until about 4 weeks ago when I was sitting in your office, and this was brought to my attention by Miro and Adam, and just saying, hey, look,
Because you guys manage our risk management.
yeah, so they wanted to know kind of where the protection is, how does it extend? We're talking about a whole new entity here, Cyprus, and trying to continue to really serve your clients along with many others to make sure that they're compliant in this particular case. And so I've been running this up the flagpole with several different risk managers, and I've had to basically tell the story to them. Underwriters aren't typically too entrenched in owning their own businesses or entities, so this is news to them, and really feel like it falls under the scope of what a typical business law firm or business attorney would be able to do. But
With the enhanced issue being the cyber risk.
with the enhanced issue that now we're collecting a lot more private information than we ever thought we were going to.
And being compelled to transfer that over.
Yeah, and that's really where we're at right now, and trying to find a cyber liability form that will cover Cyprus in particular,
Right.
to basically conduct all this information.
So the final thing I want you to close out with is the personal liability of the person pushing the button. Talk a little bit about what's that person called?
This will be the company applicant.
The company applicant.
So as Nate just said, the company applicant is the person who's pushing the button. It can be a paralegal. It can be someone the person who's forming an entity on behalf of the reporting person or the beneficial owner. And that company applicant is going to have the same liability as everyone, as a beneficial owner himself, essentially. So let's say it's a huge amount of liability for the applicant, because let's say the reporting didn't go back in the last 10 years and find all the DBAs. Strict liability, the company applicant's on the hook too.
Wow.
So on that note, on that cheerful note,
Yeah, this is great. I feel so.
I think we can wrap up this discussion and maybe move on to things like what we're doing to try to solve this problem for clients, to address it, to help everybody know that they're not going to just get left holding the bag and trying to figure this out for themselves. We are committed as a law firm to helping our clients navigate this and find a way to comply, whether it be direct or through a service entity. But yeah, so that's what we can close out with that.
All right.
Important information, kind of breaking information. We're still early in the year, whereas Chase said people are still trying to figure this out, but it's I think more impactful than they thought it was going to be. They thought it was going to be like, oh, we'll just get everybody to give us this information and send them to prison for how long?
2 years.
2 years if they don't comply, up to 2 years. But hopefully it won't come to that. So
All right,
with that, we will bid adieu.
make it a beautiful day.
Thank you for joining us today.
I hope you enjoyed the discussion and the information we shared.
We hope you enjoy the information contained in today's podcast and find it useful.
We hope you will join us again next time as we explore new areas of interest to our listeners or current issues we believe are important to discuss.
If you enjoyed this podcast, please subscribe so you are notified when future episodes are released, and also share it with a friend that you think would benefit.
If you'd like to meet with a member of the Expert Network team or have a request for a special topic you'd like to have us discuss on the podcast, submit those requests to info@expertnetworkteam.com. That's info@expertnetworkteam.com.
Thank you for joining us and have a great day.
Thank you for listening to this podcast. We want to remind you that listening to this podcast does not establish a client-professional relationship with any of the professional firms represented, including guests, nor does it constitute legal, investment, accounting, or other advice of a fiduciary nature. The views expressed are those of the professionals only.
Investment advisor services may be provided through A&I Wealth Management. Securities may be provided through Genios Wealth Management.